Justice Saab, Jai Hind, Namaskar. Justice K.G. Balakrishnan, patron to our summit over the last few months, and a project which is being taken forward by Vision India Forum to celebrate 75 years of India's glorious independent history. We have been joined by Ajit Balakrishnan, the founder of very pioneering online site called rediff.com, and a very knowledgeable gentleman. The topic today chosen, which is now taking and gaining a lot of ground in India, is the arbitration issue. And arbitration is something which is a parallel system of judicial functioning, so as to help the cases which are lying in crores pending in the courts of India because of the lack of the current infrastructure. It is a mechanism through which a lot of pending disputes can be settled. No better person than K.G. Balakrishnan, former Chief Justice of India, to speak on this subject. And we'll be joined by the guests as we move along. But today, sir, we wish to hear from you in detail about, like we heard on the Constitution Day, about what is arbitration, history of arbitration, current legislations that have impacted the arbitration laws in India, and controversial as well as important arbitration issues and the way forward. Sir, over to you. Look forward to you. But before we start, opening remarks from Ajit Balakrishnan is already on board.
I came to listen and learn. Hello. I came to listen and learn. I do not have much expertise in this area. I'm present as a humble, knowledge-seeking person. And so please go ahead.
Okay. We go straight away to the chief guest and the main speaker on the subject, Justice K.G. Balakrishnan.
Mr. Sajiv Balakrishnan.
Okay, we start. We have a Balakrishnan team today. Ajit Balakrishnan and K.G. Balakrishnan ji. Both are there.
Oh God.
Okay. Very good. So I will briefly talk about the Arbitration Act and the various provisions. It is really from the layman's point of view, not very technically, what is the arbitration, how the arbitration is being conducted in India, what are the types of arbitration, what is the law which is provided for arbitration. We had Arbitration Act 1940, Arbitration Conciliation Act. Arbitration means a dispute between two parties is settled by a third party who has no interest in the subject matter. This arbitrator is settling the matter. Arbitration conciliation, and for settlement, some sort of conciliation is required. That is why Arbitration and Conciliation Act. So the arbitrator is settle the matter. He himself has no interest in the subject matter. The arbitrators they settle the matters of the disputed parties. This arbitration, now there are large commercial transactions in India and all over the world. They are to be, when the dispute arises, they are to be settled. And going by the present statute, I don't think that the court can take up that load, because the court is already burdened with various types of cases, constitutional cases, civil cases, criminal cases, labor cases, service matters, all these are there. And the commercial matters is to be carefully considered, and the entire nitty-gritty has to be considered, and finally an award is to be passed. For arbitration, the final thing is generally called the award. Award is passed by the arbitrators, then that is to be enforced. And what are the major provisions, the procedure for arriving at an arbitration award? We had, as I said earlier, we had 1940 Act, and then when the world economy developed, all over the world countries started having trade relationship. United Nations thought that we should have an international arbitration act. That the United Nations have considered this aspect. They appointed a group of eminent personalities, and they drafted a model, the code, that is unilateral model law, what we called, was passed by the UN Commission on 21st June 1985. The international, all the countries who are parties to the UN Commission, they may take this as a model and form a arbitration conciliation and draft an arbitration conciliation act based on the unilateral act. And based on the unilateral act, we have 1996 passed the Indian Arbitration Act, Arbitration Conciliation in 1996 Act. The arbitration, as you know, there is a domestic arbitration and international arbitration. Domestic arbitration is when the parties are, both parties are, the disputed parties are the commercial parties, commercial proprietors, or the parties or individuals, or both are Indians. When one of the parties, whether in multinational corporation, which has got interest in the country outside India, or one of the parties, dispute is between two parties and one of the parties is outside India, is that person is not a resident of India, or a person who is an institution which has got foreign the headquarters or registered in a foreign country, then that the dispute between that party and Indian, the origin party, is called international, such international arbitrations. There are separate some procedure difference between the domestic arbitration and the international arbitration. How the arbitrators are to be appointed for international arbitration, and how the arbitrator is to be appointed for domestic arbitration. The Act is mainly concerned with the domestic arbitrations. International arbitration also, provisions are made in the international arbitration. So how an arbitrator is appointed, we will start from in the domestic arbitration. One of the parties, how they have entered into an agreement with another party, and the dispute arose between that party at a later stage. Then they have to seek a remedy. Then they have to send a notice to their party. There's such and such a dispute is to be resolved. I propose to suggest this such and such a name as my arbitrator to resolve. If the other party does not respond to these, then the party can go to the court and appoint an arbitrator. So within 30 days, the other party should respond and say that we also we do not agree with you that we appoint so and so as our arbitrator. Then there could be two arbitrators, one for the one party and the other for the claimant, and one for the respondent. There could be two arbitrators, but the arbitrators shall not be always even numbers. So these two arbitrators should they must select a third arbitrator, that is called presiding arbitrator. So the third arbitrator is called the presiding arbitrator. So if they are not coming to an understanding as to who should be the presiding arbitrator. Sometimes the parties may not agree. Sometimes the one party will suggest A, the other party will not agree that, other party will suggest B, the other they will not agree. Then they have to go to the court. The court will appoint the presiding arbitrator. So there will be 3 arbitrators in all these when parties are not when so there will be sole arbitrator when the one party suggests and the other party accepts it, and there is sole arbitrator is called. The other is 3 arbitrators will be there. That is how. Then the arbitration proceedings starts with the appointment of the arbitration. These arbitrators. The arbitrators will call for the claim with the first. The person who alleged that there is violation, I am entitled to get damages from the other side. They are the claimant. They have to file the claim petition, and the other party has to file his response. He can be either file a counterclaim denying the allegations the claim, and he can file a counterclaim or make a counterclaim and also seek a set off from the other side that we have paid such and such an amount that is not considered by you. So there is counterclaim and set off and all. Both parties would file the claim, these claim petition, claim and counterclaim. Thereafter the proceed such a document, but they will deny the contents of document. So such disputes are. Then the arbitrators will ask whether they want to produce evidence to support their claim or the counterclaim. Sometimes the witnesses are examined, and for the claimant side and on the respondent side. For as you know, the CPC has been amended recently, and instead of filing the witness being chief examined, they themselves can file the chief examiner in the form of an affidavit. So usually the witnesses are proposed, the witnesses proposed to be examined will be, the list of witnesses will be given, their affidavit will be given in advance, and the witnesses will be presented, and they will be cross-examined by the other side. Detailed, usually sometimes detailed cross-examination is done by the counsel appearing for the other side, touching upon all aspects relating to the contract between the parties. So this is because these are being done in detail. The court cannot afford to spend so much of time for these sort of proceedings. That is why the arbitrator is arbitrator. They are either retired judges or lawyers or other interested other parties and all. And I must also say, as regards suppose an arbitrator is appointed by the court, then those who is proposed to be appointed, he should give a declaration. He should give a declaration to the parties as well as to the court as well as to parties. So that the giving out the details, I have no interest in the subject matter or the dispute. I have no relationship with either by the parties, or I never was their lawyer, or I never give any legal opinion or assisted in any manner to either the petitioner or to the respondents. I am also is not likely to be legal representatives of the any of the parties. I have no interest in the subject matter of such a declaration is to be given by the arbitrator who is proposed to be appointed by the court. So that is the section is envisaged the various the nature of the relationship with this, either as a counsel or as a other relationship or as a friend or any other sort of relationship is there, so that it may create a loss of confidence. If the impartiality is likely to be challenged at a later stage, such a condition or circumstance exists, he shall not be a party, he shall not be an arbitrator. So that is one condition in the matter of the appointment of arbitrators, which is after the award is passed, the one party, he is having interest in the subject matter. So even in England, such incident had happened. In one case, a judge was the decision of the judge was challenged. Don't meticulously consider such cases in India, whether such but in England they are very sensitive to such things. If the person, especially in the arbitration, if we are deciding a dispute between two commercial parties, and arbitrator is holding a fairly large number of shares or even small number of shares of the particular company, he is an interested party. So he shall not enter as an arbitrator to decide the disputes between the parties. That is the moral and ethical the thing an arbitrator should do. So for that, initially he has to give a declaration. So the declaration is to be given. That is how the. Then one thing is to be noticed that in the arbitration proceedings, provisions of the various provisions of CPC in civil litigation, CPC is to be plain, written statement, amendment of pleadings, then the written statement, all these are meticulously stated, parties and all in all these are stated. But these provisions are not so scrupulously followed in arbitration proceedings. CPC, but the general provisions, because the CPC is only a general provisions, how a dispute between a civil litigation between the parties, that such a litigation is to be decided. So the CPC provisions, we cannot say they are not applicable, but nevertheless they are applicable. But we cannot strictly say that the CPC provision, because a little more freedom is given to the arbitrators to decide the facts, how the document is marked, if there is any. If in the civil litigation, if the CPC provisions are not scrupulously followed, the appellate court can readily find fault with the trial court. Why this provision was not, why the impleading application was, how the matter abated, why it was not taken. The abatement application was barred by limitation, why it was not taken care of. All these is very carefully scrutinized, and the lawyers will be very careful in alleging such facts and to find a ground in the appeal memorandum. But the CPC provisions are not that strictly applicable in the arbitration proceedings. But nevertheless, the basic provisions of CPC has to be followed, because that is a general provisions governing the proceedings for resolving the dispute between the parties, civil dispute between the parties. So such a method is to be we have to follow. And so also the Evidence Act also. Sometimes the Evidence Act is not strictly followed in arbitration proceedings. Sometimes some documents are not as you know, under the Evidence Act, there are very stringent provisions regarding the admissibility and relevancy of the documents. But such a admissibility and relevancy of documents are not strictly being considered in the matter in the arbitrations. We can look into the document and consider whether they are admissible, whether they are relevant, they are useful for the purpose of resolving the dispute. So we will not scrupulously follow the provisions of the Evidence Act. Evidence Act is a beautiful legislation dealing with the various provisions, how the evidence is to be let in, what are admissible document, what are the relevant document, what is the presumption that is to be required under the Evidence Act, the various provisions, the extent, admissible act, inadmissible provision, conclusive provision, inconclusive, are all detailed in the Evidence Act. But such provisions are not strictly followed in the arbitration proceedings. These are the procedural matters which in these arbitration proceedings are made. So the arbitrators are given a fairly good freedom to deal with these matters. It may be considered in a fairly justifiable manner, and the parties are to be taken. Here the parties follow the natural justice principles and then decide the matter. So while deciding the matter, so many incidental problems may arise that they can either consider. Suppose the party is a minor and he cannot represent in the proceedings, so guardian needs to be appointed. Sometimes the person himself, the arbitrator, the party is incapable of dealing with his own matters, then a guardian is to be appointed, be exercised. Earlier, some provisions are the appointment of guardian and the protect, and there are also securing suppose the other party is due, a huge amount is due from the respondent to the claimant, and the respondent is making efforts to dispose of that property, whatever he has got. The respondent is hastily making and to protect the subject matter, or even the subject matter itself is so to be transferred to third parties. And when such matters are there, the Section 17 applications are there to appointment of guardian, appointment of to protect and preserve any goods, the subject matter of the dispute, the securing amount in the arbitration. The amount in the arbitration is likely to be passed, a huge amount is likely to be passed in favor of the claimant, but there is not a single penny with the respondent, so he will not be able to recover anything. So all these Section 17 applications can be filed to preserve the subject matter and the incidental matters. These are all it is usually done in civil cases. So that is then the party also can now go to the court and seeking. Suppose suddenly the respondent is trying to dispose of the property, and the claimant will be, there is no arbitration proceedings, no arbitration is pending, arbitration is not appointed, that is in the process of appointment. Then he can immediately go to the court and get a interim order. But only thing is that he must file the arbitration proceeding within 90 days of such filing of the petition. So such provisions are made. The various
which comes to my mind.
Provisions have been made in the Arbitration Concession Act to protect the interests of Then
Just sir, one small question I just had in mind. If you may just try to interrupt, sir. One small question. Can political parties vis-a-vis the government of the day have arbitration proceedings initiated between them?
Political parties, I don't think any political parties would seek arbitration. There are innumerable methods to to resolve the dispute between you mean two political parties?
Yeah, no particular political party.
So if these
suppose
are all intended
vis-a-vis
for
the-
commercial transfer.
Okay. Yes,
Not
understood.
audible.
Understood, sir.
Visham is not. These are all disputes or commercial transactions, not resolution of politics. This is not, Arbitration Act is not intended to resolve any type of disputes. There are innumerable disputes between the parties. So various forums are created. If there is husband and wife dispute, it is not the arbitration. It is the family court that is the forum. If there is the guardian for father and son, the Guardian and Parts Act, the provisions are there. So this is only commercial transaction between the parties. Maybe parties may be individual, parties may be corporate parties may be companies, parties may be partnership firms, or any the legal personalities. He should be a legal person. So the various other provisions also is the arbitration tribunal is for execution of work. But, so that can be an expert in the field would be able to give a better picture on the dispute than the appointment. But it is very rarely the experts are appointed because the parties themselves give evidence. They act on the evidence adduced by the parties. So then there is one important provision in the Arbitration Act, that the time limit for preparation of the award. Under Section 29A, the award shall be passed within a period of 1 year. So otherwise, all these arbitrator, the arbitrators, they left to themselves may have large number of cases with them, but nevertheless, they should, after hearing the parties, they should decide the matter within 1 year. Within 1 year of the appointment of the appointment, the tribunal, the arbitral tribunal enters upon the reference. That is, the arbitrator receives evidence. It receives notice of the award, notice of his appointment. Then that means he enters upon the reference. From that date, 1 year time is given for preparation, the final passing of the award. So that is also subject to the extension, and could be 6 months, could be extended with the court can grant time another 6 months. And there is also a very peculiar provision that if the extension is granted, there could be reduction of the arbitrator's fee by 5%. All these, these are all the also days that the arbitrator shall pass award within a period of 1 year, subject to a one extension, that is 6 months extension can be. And if for very valid reasons are there, further, because of the pandemic period, all arbitrations are get delayed. They are not able to continue with the proceedings. So the Supreme Court also has said that this period will not, the Limitation Act itself has come to a complete halt and standstill. So everything is getting the passover due to the pandemic situation. So the 29A and the time limit prescribed there is of no consequences for the present day arbitration proceedings. Then another important provisions, and that is the section 34. Once the award is passed, the party, after getting notice of the award, he can challenge the award before the court. That is, and also the international award could be challenged. The main ground on which a challenge could be made is that it is against the public policy. One is induced by fraud or corruption. If the party can establish that this arbitration award is induced by fraud or corruption, that is liable to be set aside. And it is there is a patent illegality apparent on the face of the record against the fundamental policy of Indian law, against basic notions of the morality and justice, then it is public policy. So it is all very petty words. If it is a public against public policy, what is this public policy? It was examined by the public policy, examined by recent decision, also the old decision. What is this public policy? There are decisions of the Supreme Court deal with how this public policy has been defined. This Renusagar power plant versus GC, General GC, Supreme Court, page 860, is explain the public. What is this public policy? Against public policy. Public policy, as you is an unruly holds. So it is said that it is against the fundamental policy of Indian law. Against India, we cannot say that. I find difficulty in accepting that. Against the justice and morality. If it is against the justice and morality, the moral values of then it can be said against public policy. So the award could be challenged not only on ordinary law, but if it is patent illegality apparent on the face of the record and against the fundamental policy of Indian law. Fundamental policy of Indian law, because so suppose some of the contracts are prohibited under Indian law. It is the contract agreement itself is based on such a contract that the dispute arose with you. So it is not enforceable under Indian law. Wagering contracts are not enforceable in India. So the wagering contract, the award is based on a wagering contract that cannot be enforced. Fundamentally, the party can say that it is not enforceable. So there are some basic principles of Indian law that is called the public policy. But the public policy by itself is a difficult thing to define, and the court is given. But there is a general, the court shall not normally interfere with the award passed by the arbitrator. If for silly reasons it is not proper for the court to interfere and set aside So this arbitration award, the Arbitration Act of the 1996 also underwent some amendment in 2000. There was an amendment 2015, the 2019 also some ordinance is underway. So by instead of Chief Justice means Chief Justice means the High Court. They substituted the High Court. So any judge of the High Court can do the. And the Chief Justice of the Supreme Court has been the Chief Justice of the Supreme Court of India. So that amendment has been made. The court so that such a change, some for the purpose of expediency and quick, some amendment also so to be made. So the section 9 interim measures, so the court shall not interfere on with the pendency of the proceeding. Court shall not interfere. And the section 17 powers exercised by the court, the arbitrators have also been given same the powers. So these are all the main salient features of the arbitration conciliation, and this act is intended to have a speedy and decision-making process of the commercial transactions. Any country which has got economic progress, desires economic progress, should resolve the commercial disputes at the earliest and should progress. We shall not waste our valuable time in simply discussing things over it. We should find whether right or wrong we should not under no judicial system we can give complete justice to any parties. There may be some here, some ye may have some complaint, we may have some complaints. But it should be free from such complaint, of course, but it should not be induced by fraud or corruption, or it shall not be caused by violation of natural justice, violation of the basic principles of justice and equity and good conscience. These are all the basic things which govern the decision-making process in this country. If that is there, then the people are satisfied. People will go to court. People will invoke the jurisdiction of the act, and people will be satisfied by and large. That is very important for the smooth progress of the country. The economic activities would be activated only if there is a proper justice delivery system. If there is a failure on the part of to resolve the dispute and their money is blocked for years together, nobody would come and invest money in any activities for the welfare of this country. So the Arbitration Act is a very, very important legislation. The government should take all steps to see that the arbitration is done in the right perspective and in the right form. It should be done. It shall not be swayed by arguments which are the self-interest argument. It should always serve the public purpose. Public purpose should be served. That is more important than so the resolution of the dispute is an important aspect, and it is by and large fairly working well. And only thing that because of this pandemic situation, many of these are just getting blocked. And we have got fine judges in this country. They are all prepared to do their work. Even and India is fortunate in one way because our retirement age is 65, even the Supreme Court. And those who are healthy, they can continue for another 10 or 15 years. Whereas in American Supreme Court, we won't get any retired judges. There are no retired. There's no such species in America. In Canada, it is 75 years. In most of the countries, not less than 70 years. But India, the retirement age of High Court judge is 62, and Supreme Court is 65. So they are bright, experienced judges are available for the field of arbitration. So along with the justice delivery system in the court, the arbitration proceedings also can move on. But it should be streamlined it should be more effective. And then only it is. So I once again
The
wish
financial
all
implications of arbitration vis-a-vis
successful effort.
judicial proceedings. The financial implications of arbitration, sir.
What?
The financial implications, the cost aspects with respect to arbitrations, domestic as well as especially international.
Cost is arbitration. Arbitrator is to be paid. The party will engage counsel for presenting their case. It's a lengthy procedure. They have to pay for the counsel.
The future of arbitration in the next 25 years, because this is India has a very kind of a questionable judicial infrastructure. I was asking you in a few days back in the budget show that whether there should be special provisions for at least 1% of the GDP that should be allocated for the judicial infrastructural reforms, the petition that was filed in the Supreme Court last year, but which was referred back by the Honorable current Chief Justice Ramannaji. So judicial infrastructural reform.
I have no idea.
What do you want to say about the arbitration future in this country?
Arbitration has got bright future. So only thing that it is to be streamlined properly. It should be in the all. There are judges who are very learned judges are available. They would the parties should cooperate. Everything will work well. No problem with regard to that.
So important issues like Rafale, there have been question marks wherein Indian government has ceded important negotiating position on the table with respect to the French government. Any views on those kind of important cases?
Important cases on what subject? So many cases are pending, maybe pending or Supreme Court.
Recently, Madam Kakkar is also joining us now. Stuti Kakkar is the former Secretary Disability Affairs, Government of India. She was also Additional Secretary Commerce Industries and then Chairperson of NCBCR. She's on board. Sir, some views of yours on the subject of Rafale kind of negotiations, wherein the Indian government through the PMO is, there are some sketchy question marks about the negotiations that were ceded to the French government by the Indian government, despite having a strong negotiating power with respect to the sovereignty and the bank guarantees that were asked for.
I am not aware of all these governmental activities.
Billions of dollars lost in Vodafone case, 2020. Ajit Balakrishnan is there. Any comments?
I am not fully aware of the nitty-gritty of the Vodafone cases. Vodafone, I think it was considered in detail by the judicial forum also. Then it was, now we cannot comment on that.
Yeah, I can't comment either. But in your opinion, Justice, what are the steps necessary to speed up action of decisions? What are the constructive steps you may recommend to speed up the whole process by which justice gives? Because I say this because in India, we are by and large a country where we all have, complete belief in a judicial system to resolve problems. But as you correctly pointed out, it's taking time, and time is, as again to quote you, speed of justice is important for an economy. What are the suggestions you have to speed up the arbitration process?
This is already 29A provision is there. Within 1 year, it should be, award should be passed, and sequence time is here. And if it is not passed within that, the arbitrator, the whole thing, that should be strictly followed. But unfortunately, everything was working well. When this pandemic situation came, now they given a go by, limitation is given a go by. So that is the problem. Otherwise, it was working well. And almost all the...
Is it conceivable to think of a speed not of 1 year, but of 3 months? You can close all arbitrations.
The difficulty is that some of the judges have got several arbitration. Once the matter is adjourned, So only they would be able to get a time after 3 weeks or 4 weeks, another date.
They are
So that
overloaded.
is also
They are overloaded.
overload.
Are they? Yeah.
Overload. That is it.
Stuti Madam, you've been, Madam Stuti Kakkar, you've been the Secretary Government of India and an IAS of the 1979 batch. She has handled many positions in the Government of India, having demitted office lastly as the Chairperson of the National Commission on Protection of Child Rights. Currently also she is serving in the board of NBSA and other institutions, including Save the Girl and so many other things. Madam, your second views, because we had a long detailed overview of the process of arbitration, including the laws, legislations, international processes from the former Chief Justice of India, Honorable Justice KG Balakrishnan. So your view, Madam, your views with your experiences of handling different ministries and departments under the Government of India, how arbitration is important, relevant, and where are the issues where it needs to puck up, where it needs to speed up the process.
Amit, thank you for this opportunity, especially this opportunity of hearing former Chief Justice Balakrishnanji and Jeetji. Yes, arbitration is a very important, arbitration and mediation, they go hand in hand. Actually, there are various steps to getting some kind of justice. You know, where the normal processes are not very, are very difficult. In fact, my experience has been limited to Juvenile Justice Act and POSCO Act, where I was heavily involved, I would say, with ensuring that children are protected and they get justice. Because a lot of children get into crime because of perceived and actual injustices done to them. And we must remember that criminals are not born fully grown up. They grow and children become full-fledged criminals. And when they grow up, the crime kind of escalates. And this is what we need to prevent, because we need to have a safe society. One place where I think another alternate system to our formal system is very important, that we recognize this process. That is restorative justice. You know, it is very important, because when one was doing the POXO cases, a lot of child abuse is taking place within households, where the normal process of punishment, crime and punishment cannot, it should take place, but it cannot take place. And especially where the parents, child's own near and dear ones are involved. So this is where we need to bring in a separate concept of a sort of a process which will give justice and closure to the child. And at the same time, you know, ensure that the family structure is safer for the abused child. And sir, I would like to hear your views on it. Justice Saab?
Oh, okay.
It is a, you know, it's a very difficult area, and it all continues to puzzle my mind.
Really a difficult area. I found this POSCO and child abuse. It has become very difficult to resolve, and persons in authority are finding it. Large number of cases are filed. Some of them, of course, are now convicted. So huge punishment is inflicted. But the children, when we talk of some sort of education to children, so people so no. These are all sex education. We shall not. But the children should be told what is it should be. We should develop a sort of educational system by which the children should be what is bad, what we should, what is the circumstance they should avoid in the family surroundings.
On one side, we have to teach them trust. On the other side, we have to teach them that you don't trust. And but especially when it is so much, you know, there's so much of incest, so much of child abuse within families, I would say.
Yes. I know that.
It is
in my state also, it is very, in Kerala also, it is.
It is a lot. It is a lot there also. It would be in most places, sir. It is just that in Kerala, everybody is educated, so everybody would talk about such things.
These people, North Indian people are illiterate. They do not know and they don't have time to look after the children carefully because they have to make a living. They spend time to make a living, and how they would devote careful time to their children. Their children are
This
left
is
with
one place I don't think I agree with you. It is just that the poor people have no privacy. Everybody walks
yeah.
into their houses and you find out
Yeah.
that what you want to know. In houses of rich people, you do not know because they have the means to suppress justice and
Yes,
to pretend that nothing's happening.
Yes,
And
yes.
another sort of restorative justice would be one way of seeing that the children get closure, because not a lot of them would like to come and give evidence, relive the trauma, and
Yes,
damn their own parents, grandparents, uncles. And yet, somewhere. And another issue which has often troubled me, even though the Honorable Supreme Court took a different view on it, was the case of these mentally, intellectually disabled women and children. Because strictly speaking, if the RPWD Act doesn't mentions only fiscal age, but a person who's mentally not evolved beyond
mentally.
18 years, I think should get the benefit of being a child. I mean, of course, legally that is, there are many issues which came up during my time, and in which I felt we could have a more liberal interpretation of. And another case, even under the POXO Act, there was this case of a 4-year-old child abusing another child, girl child. And everybody was saying that we must lodge an FIR. I said, IPC gives benefit of innocence to any child less than 7 years, but it's a special law which does not mention age. And therefore, I would like your views on such, issues which are, in a way, legally, yes, there are certain legal provisions, but practically they are different,
Yes, madam, thank you so much for your views on the child abuse, POSCO issues, juvenile issues. There are 1 or 2 more sectors we'll touch upon, and then we'll have the closing remarks and close in the next 5-7 minutes time. Ajit Balakrishnan is the founder of Reddit.com. You represent as the pioneer of the IT industry in this country, one of the citizens we should be proud of. I mean, IT, social media, it is creating a lot of troubled waters and furor and news in the country. It is more of an anti-social or political media now. Sir Justice Saab, do you think arbitration, that the Facebook kind of issues, the kind of turmoil that is happening within the government and these companies which have set up shops outside India, do you think there is a scope of arbitration, and arbitration holds a very, very strong way of resolving such disputes when it comes to such IT related subjects?
The question addressed to me or to Justice Balakrishnanji?
They are not commercial transaction. They are disputes between some of the dealings. I don't think that arbitration can play a strong. It depends on the nature of dispute. So
cyber issues, cyber security issues, they are
cyber
heavily
issues
commercial.
are
Heavily commercial.
Criminal in nature. Criminal law has to be invoked rather than the arbitration.
Okay, section 498, section 498, family disputes.
That cannot be, that is not a commercial transaction. All to be decided by the family court.
Okay, and for example, there are issues with respect to Me Too campaign. Nowadays, this is a very important subject in India. Now it's gaining ground in the last few years. Me Too, can arbitration come in?
No. Nothing. They have no Me Too and all these are outside the arbitration.
It's not a commercial dispute. I think what Justice Balakrishnan is emphasizing is the Arbitration Act deals with commercial disputes, right?
Ultimately, the
So
goal is
the
commercial.
principle of arbitration can be applied anywhere, sir. I mean, it is, why should it be limited to the commercial world? I mean, like, I would say if somebody was harassing me, I won't try to go to a regular court and be subjected to all kinds of questioning and cross-questioning and all that. I would rather like it to be resolved across the table so that the person with whom I'm having a problem, I mean, I as a woman, I may be able to put across my point of view and that person may be able to put across his point of view, maybe, rather than, and then
Ultimately,
we come
it's all
to some
commercially
kind of
settled.
a,
Ultimately, it's all commercially
fighting over
settled.
the
Let's be
entire
very
thing.
clear.
Huh?
And ultimately, it's all commercially settled.
I may
No,
not
no.
need, again, as we go back to the principle of restorative justice, I may not need any commercial, monetary compensation. Maybe just a sorry would be enough. Maybe just an apology in public would be enough. Because,
Yes, yes, that is what.
the women are subjected to so much of inquisition with all kinds of character assassinations, that it becomes very difficult. I mean, it did happen to me once. And ultimately, you felt you must leave the organization because, every day interacting with people who are harassing you, giving an explanation to X, Y, and Z, it just became too much. So it is often that the loss that you suffer by way of your reputation, by way of your standing is much more than whatever anybody can compensate me. I mean, money doesn't compensate because then the thing would be, wo paise ke liye kar rahi thi. I mean, it is at times, I think there has to be some system, more softer system than to just, legal proceedings about everything. Not everything is a crime. There are many shades to criminality.
So recently, new acts have been, promulgated from time to time. For example, RERA for the real estate sector. Do you think arbitration needs to be brought in and inculcated in a very stronger manner in such kind of new acts, so as to, improve the efficacy of such acts being brought into place?
What act?
The Real Estate Regulation Act, these kind of new acts which are coming, should arbitration be inculcated in a vehement manner to increase the efficacy of such new legislations?
They are all real estate regulation because the construction of they are regulatory mechanisms to resolve the dispute. There is authority will do the justice. They have their own mechanisms, their own the acts give relief to the parties. So they are ready. If arbitration is there, it will be only get delayed.
Okay, closing remarks from you, madam.
Nice. It's always a pleasure joining you this webinar and hearing luminaries like Justice Balakrishnan and Mr. Ajit Balakrishnanji, though I think I missed most of it. I had some other, I became a little late. And it is also an achievement, having two people with the same surname in one webinar.
Okay.
Thank you. Thank you all. Jai Hind.
Thank
you.
you.